Hello, I'm Judge Luke Mays. Welcome to Municipal Court Plea and Arraignment Day. There are three areas I would like to cover with you before we get started. First, your constitutional rights. Second, the purpose of Plea and Arraignment Day. And third, I will briefly explain the trial process. With regards to your constitutional rights, you have the same basic fundamental constitutional rights that apply in all other courts.
Your constitutional rights are the presumption of innocence. You are considered innocent before this court until proven guilty. The right to remain silent. You also have the right to an attorney. You may hire your own lawyer if you like, or if you qualify, you may get a court-appointed public defender. In any case before this court, we encourage you to have a lawyer. A lawyer's job is to provide legal advice, which can help you decide how best to resolve your case. Please understand that the people that work in the court system, the clerks, the bailiffs, the judge, and the police officers are not allowed to give you legal advice and are not allowed to evaluate your case or tell you how best to handle it. This is the job of an attorney, which is why we recommend that you have a lawyer. You have the right to a trial. There are two types of trials, a jury trial and a non-jury trial. At any trial, you have the right to cross-examine witnesses that are brought to testify against you. You have the right to bring documents, evidence, or other witnesses to testify, and you may choose to testify on your own behalf.
If you have any particular questions about your constitutional rights or need a more detailed explanation, please let the judge know when your case is called and these rights can be explained again.
What is the purpose of Plea and Arraignment Day? Plea and Arraignment Day is not a trial day. It is a pre-trial day. Today is a day we use to get cases resolved that can be resolved without a trial. Those cases that cannot get resolved get moved over to a special day specifically set up for trials. Please note that on plea and arraignment days, police officers are not required to be in court. Therefore, you will not see them here today. Police officers are here on trial days, and in fact, the court requires them to be present for trial. The arraignment portion of today is to make sure you understand your constitutional rights, which we have just reviewed, what you have been charged with and what your ticket is for, and the potential maximum penalty you may receive per ticket or per charge. The maximum penalties for each charge are generally governed by state law. It does not matter who writes the ticket, the same maximum penalty applies. For most offenses under state law, a maximum penalty can be up to a $1,000 fine plus state taxes and surcharges and or up to 1 year in jail. The solicitor will review the maximum penalties for your case with you individually. This is not to say that you are going to receive the maximum penalty, just please be aware of what the maximum penalties are for your case. Some charges have mandatory penalties attached to them. These are the bigger cases such as DUIs, driving with a suspended license, driving with a suspended registration, and driving without insurance. These types of cases can carry mandatory minimum jail time, mandatory license suspensions, mandatory requirements that you attend a defensive driving school, or mandatory requirements to complete a certain number of community service hours. If you have a case that requires mandatory penalties, we will let you know what those penalties are. Also, please be aware that if you are in a situation where there are repeat offenses, the fines and penalties may be higher. The plea portion of Plea and Arraignment Day is to give you the opportunity to enter a plea. Generally, there are three types of pleas that you have the right to enter. The first is a guilty plea, and the second is a plea of not guilty, and the third is a nolo contendere plea, which is often called no contest. There is no fourth category called guilty with an explanation. It simply does not exist. It is possible that you were told to come to court, see the judge, tell the judge that you are guilty, and then give a 20-minute explanation about why you did what you did, in hopes of lessening the penalties associated with your charge. That does not work in this court. The reason that it does not work is because we do not negotiate fine amounts. For every offense, there is a preset fine amount. Please understand that the fine is the same regardless of whether you mailed your payment to the court, paid at the window earlier today before we got started, or if you wait to plead your case in front of the judge. The fine schedule stays the same, and the fine amounts do not change.
This may be different than what you've heard or seen in other courts, but the reason why we follow a set fine schedule and do not negotiate fine amounts is because we want to treat the same types of cases the same way. By using a set fine schedule, we are able to treat people that have the same types of tickets the same way. It is a way to be consistent with everybody here today and with the people that came to court last week, last month, or last year. There are no surprises in the system. By treating similar cases in similar ways, we are able to be consistent and predictable, which results in a more fair system to everyone.
The first type of plea you may enter is a plea of guilty. In entering a guilty plea, you are admitting to the allegations of the city against you, and you are accepting the penalties associated with that offense as recommended by state law and the solicitor. You can enter a guilty plea by speaking with the solicitor about your case and presenting your guilty plea to the judge in court. If you were told that your offense was a payable offense, you can skip this process and go to the clerk's window at any time to pay the fine and close your case. The second type of plea you may enter is a plea of not guilty. In entering a not guilty plea, you are disputing the allegations of the city against you. In this situation, your case will be set for a trial at a later date. The final type of plea you may enter is a plea of nolo contendere. A nolo contendere plea is also called a no contest plea. You are not admitting guilt with this plea, but you are also not contesting the prosecutor's ability to prove your guilt. Not everybody qualifies for a no contest plea. Whether or not you qualify for a no contest plea depends upon your driver's history, your criminal history, and the nature of your charge. No contest pleas do appear on your driver's history. The general benefit of a no contest plea for certain traffic tickets is that such a plea can save you points against your driver's license.
Entering a plea of no contest does not change the fine or penalty associated with your offense. The fines and penalties remain the same. The general drawback of entering a plea of no contest is that you can only enter a no contest plea once every 5 years. If you are not sure whether it is the best time to use a no contest plea, you should speak with a lawyer who can advise you further. As we work through the afternoon, we will make no contest pleas available, and the clerks will have further instructions in just a few moments.
Finally, it is important to have a brief overview of the trial process. If you enter a plea of not guilty, your case will proceed to trial. There are two types of trials. The first type of trial is a bench trial. In a bench trial, your case will be heard by and decided by the judge without a jury. The other type of trial is a jury trial. In a jury trial, your case will take place in state court and will be heard and decided upon by a jury of your peers. In both cases, you will have the ability to cross-examine witnesses that are brought to testify against you, the right to bring documents, evidence, and witnesses to testify on your behalf, and the right to testify yourself on your own behalf. On trial days, there is no set fine schedule, and we cannot control what happens in the county if you decide to have a trial there. You are strongly encouraged to have a lawyer if you choose to proceed to trial. Lawyers can help you with trial procedure, the rules of evidence, and all other court rules. Lawyers can also help you evaluate your case and prepare your legal defenses. Finally, lawyers can help you avoid saying things in court that may hurt your case. When people come to court without a lawyer, they want to present an explanation. Sometimes these explanations result in testimony that makes the situation worse or reveals aggravating circumstances about their case. Overall, it is important to understand that lawyers can help you find the best way to resolve your case and can ensure that you do not accidentally harm your case.
Now that we've discussed your constitutional rights, the purpose of plea and arraignment day, and the trial process, we are about ready to get started. For those of you who have payable offenses and wish to pay your fine and complete your case, the clerks will give you instructions on how to do that in a moment. Also, there may be an opportunity to reset your case to a later calendar. The clerk will have further information on that as well. As a result, we are going to turn it over to the clerks to get us started. Thank you for your attention.